So one issue that we want to really think about a lot when we're talking about giving equity, particularly to co-founders or consultants or employees, or anyone who's going to be contributing their services, is vesting. Vesting is basically a way to make sure that when you give someone some equity in your company, that they actually do what they said that they're going to do for it. So instead of saying, I'm going to give you 10% of my company and you're going to do X, Y, and Z for me, I'm going to say I'm going to give you 10% of my company, but you're going to get pieces of it over the next 4 years as you achieve these milestones or as time progresses. And the reason that you do that is you can actually have a really unfair scenario if you didn't. Let's say that you had a company and you would invest $100,000 into it and had assets worth $100,000, and then you hire someone to build an application for you, and in exchange for that you give them 10%. And then like the next day for some reason, something terrible happens and the company has to be dissolved. Well, they have 10%, they're gonna get 10% of the assets of the company without ever having done anything. That's obviously not a fair result. So what we do is we make sure that they only get their equity as they've actually produced the value to the company. This is an absolute must whenever it's gonna be services or IP that's contributed. But one thing that we do in most cases is have an acceleration clause, which says that if there's a triggering event, like a sale of the company, then all of the equity is going to vest immediately. So that way, like, you figure if the company's being sold, then all the people have basically done their jobs, right? Your consultants built what they had to build, your developers did everything they needed to do, so you're happy. They're going to get that percentage, even if it hasn't all vested yet. It's all going to vest right now, so that they get their percentage at that exit point. And when you're thinking about this and how you're going to split up the equity, that's really the time to figure out really clearly who's going to be doing what. What are the roles and responsibilities going to be? What are the relative strengths of each member of your team? What are they bringing to the table? And how are you going to reward that appropriately? That said, it's also really important to keep all your agreements really flexible because things change. Sometimes you need to pivot. Sometimes you need to do something a little bit different. So there's always that tension between having something that's really well set out, really well prepared, and having something that's flexible enough to let you deal with anything that might come up. So there's a few different kinds of economic rights that can typically be associated with equity, and these are just a few of them. Normally you'll find them either in preferred stock, in the definition of the preferred stock, or in some form of stockholders agreement. We'll talk more about preferred stock in a minute, but just for now, let me just go over these 4 kinds of rights and what they mean. A preemptive right is basically a right to prevent dilution of your share of the company. And what dilution is, you can think of it a little bit like inflation. So if you remember the chart before where we had more shares being issued, that decreased the percentage overall of the people who already had shares. So if you have 100 shares, you have 100% of the outstanding. And now you issue 50 shares to somebody, now you only have 2/3 of what's outstanding. That's called dilution. It's not necessarily a bad thing because usually when it happens, someone's adding value, so the whole thing gets more valuable. But it can be problematic if you need to maintain over 50%, for example, in order to ensure your ability to manage the company or for some other reason. So a preemptive right basically says that whenever I'm going to issue stock to somebody, I'm going to have the right myself to also issue stock to myself or to purchase stock for myself, which means that I can maintain my percentage even as other people, maybe other stockholders' percentages are going down or new stock is being issued. A dividend preference is basically a multiplier on dividends that certain shareholders, typically preferred, will get. So we could say each share of stock is going to get $1, but the preferred shares are going to get a 3 times preference, meaning that for every $1 that is going to be issued in a dividend, $3 will go to each holder of preferred. And dividend participation is sort of a similar concept. This means that like the preferred stock will be able to participate in any dividends given only to common stock. So one way that would work is if there was a dividend issued for both the common and the preferred would get its share, its dividend, and then it would also get to participate in the dividends given to the common, so it would get paid twice. It's kind of double dipping. And if you include that with the dividend preference, it can actually result in some pretty significant multipliers on how much the preferred stock is getting. Investors will seek this kind of provision a lot. It's important to know what it means. Also, the right to declare a dividend, i.e. to issue money to the owners, or to make a capital call, i.e. to make the other owners put money or some sort of capital contribution into the company. Those are also rights that can sometimes be allocated. So that's economic rights. Now we're going to talk a little bit about management rights, which are just exactly what they sound like. It's the right to run the company. Typically, a company is run by a board of directors. That's like the standard way for a C Corp to be operated. The board of directors makes all the major decisions, and then there's officers who have been appointed, and they actually execute the day-to-day business strategy and follow the instructions of the board of directors. The directors are elected by vote of shareholders, but you can have a voting agreement that says that certain shareholders will agree to vote to put a certain person in a position as a board of directors. So if you want to make sure that you're on the board of your own company, or that one of your friends is, or two of your friends are, or at least three of your friends are for every two of the investors, or something like that, then you're going to have a voting agreement that's going to make sure that that can happen. You can also have a voting agreement that says that people will vote under a certain condition to do a certain thing. You can make it do pretty much whatever you want to make sure that you have some sort of predictability into what the company is going to be doing. There's also rights when there's a sale. A right of first refusal is the right to buy someone else's shares if they're going to offer them to sell for someone else. And typically, if someone has a right of first refusal and another shareholder goes ahead and sells their shares anyways, it'll actually be rescinded. It'll be void. They can't sell the shares without giving the right to the other person. And the third party may have some claims against people, but that's a different matter. Drag-along rights mean that if you're a majority shareholder, or you have a group of shareholders representing a majority, and you're selling your interest to an investor, you can force other shareholders to come along with you. So this is actually sort of interesting. It pits the rights of someone who wants to make a sale against someone who maybe doesn't want to make a sale, maybe wants to hold on to the company, maybe thinks there's more value in staying in. But if there's a drag-along right in place, it gives sort of the leader of that group, whoever has the most shares, the right to decide to make a sale and compel other shareholders to let that sale happen. And tag-along rights are sort of the inverse of that. It's where you're a minority shareholder and you see that one of the big shareholders is making a sale, and you realize, well, now I'm going to be squeezed out. I'm just going to be this tiny shareholder and I'm not going to have any power anymore. You can say, actually, no, I want to be part of that sale too, and I'm going to force you to take me along with you, and I'm going to get terms at least as favorable as the selling shareholder. Compensation of founders and employees is another issue that you have to deal with here. And when you're making the agreement among founders, it's really important to make sure you understand what IP is being brought to the table by each person, or what IP is going to be created by each person, and that it gets assigned to the company so the company owns it. You don't want a situation where one of your, like your chief technical officer created something really awesome, but it turns out that he owns it, not the company. Non-competes and non-solicits can be really important, as well as limitations on outside ventures.